Thank you very much for joining me on this video. I want to talk to you today about selling tenanted properties. It's something we've talked about before, but we've probably got 2 or 3 issues right now that are occurring, and it brought it to my attention, and I realized it was something we need to once again stress. So I'm going to cover it again. Let me tell you a couple of incidents. I had one property listed. It was tenanted, and an agent brought in an offer, and the buyer wanted to move in themselves. It was a single-family home. So in the agreement of purchase and sale, they stated that the seller, who's the landlord, agrees to give the prerequisite notice to the tenant requiring vacant possession. And the landlord did that. He issued an N12 requiring vacant possession because the buyer required the property for their own use. And he gave it from the first of a payment date, the 60-day notice, everything exactly the way it should be. Sometime between the time the offer came in and the time the deal was scheduled to close, we got wind of the idea that the tenant had no intention of moving out. Spoke to the tenant, and the tenant said, "No, I'm not going to move out." But he said, "But I could be bought." And he said, basically, if you want to give me cash, and he quoted a figure that represented about 10% of the purchase price. He said, "You give me that in cash, and I'll move out." We had another one where we were, in this particular time, representing the buyer, and the buyer was coming in from Winnipeg. They were relocating to St. Catharines, and they were buying a property, again, that was tenanted. And so the agreement of purchase and sale called for the landlord, owner, to give the prerequisite N12 notice to the tenant requiring vacant possession. And the landlord did that, gave them the 60-day notice on the N12 that the buyer was going to require the property for themselves. And in this particular case, the tenant was going to turn around and buy a property themselves. But instead of lining up the closing date on the property they were buying with the time they had to vacate, they decided that they were going to close on the property they were buying 2 or 3 weeks later. And the reason for that was that they were planning a holiday and they didn't want to disrupt their holiday. The agent representing the seller gave me consent to talk to the tenants themselves, so I called the tenant. In the course of the discussion, I was offering them some alternate space where they could move their furniture and so on. And I said, "You know, by law, you have to move out." And they said, "No." They said, "We contacted the board, the tenant board, and they said, you don't have to move out. It's going to take them months to evict you." So they stayed put. And it caused a problem for the buyers. And you can imagine if a buyer is moving in, as in the case with both these examples I cited to you, all excited with their moving van all full and everything, and they pull up to the curb, and the tenant hasn't moved out, it causes some serious problems. Well, you could say, well, the real estate and the seller, everybody did their job. They provided the notice. It's the notice that the board requires and so on. So that should be the end of it. But it isn't quite, because the agreement of purchase and sale doesn't just require giving notice, it requires vacant possession. In the pre-printed part of the form, and let me read it to you, it says, "Upon completion, vacant possession of the property shall be given to the buyer unless otherwise provided for in this agreement." So the fact the agreement provides for giving notice doesn't guarantee the property will be vacant. And anytime you're dealing with a third party, you got the buyer, you got the seller, and you got the tenant. You can't always guarantee what a tenant's going to do. And if the tenant doesn't move out, the seller's in breach because he's promised vacant possession. That's why I always encourage agents to, at the very minimal, put in at the end of that notice to give to the tenant. However, the seller does not warrant that the tenant will in fact vacate. And in the event that the tenant does not vacate, the buyer agrees to close the transaction, assume the tenant, and take over the eviction process. The Ontario Real Estate Association has a clause for these situations, and I think they did an excellent job with this clause. And I'm going to take a minute and read it to you, and we'll pop it on the screen so you can follow along and read it as well. I think it'd be worth your while to incorporate this in your agreements when you have a tenanted property. It says that the buyer hereby authorizes and directs the seller, and the seller agrees, when this agreement becomes unconditional, to give to the tenants the requisite notices under the Residential Tenancies Act requiring vacant possession of the property for use by the buyer or the buyer's immediate family, effective as of such and such a date, and the seller agrees to deliver copies of the requisite notice to the buyer immediately after service of the notice upon to the tenant. And then it goes on to say, the buyer and the seller hereby agree that in the event the tenant fails to vacate the property prior to completion of the transaction, the buyer agrees to assume the existing tenant upon completion of this transaction. And then upon vacant possession being provided to the buyer or the buyer's immediate family agrees to take possession of and occupy the property forthwith hereafter, and the buyer agrees to provide the seller with a written indemnification on completion, indemnifying the seller from all action, causes of action, claims, and demands of any kind whatsoever that may occur in the event that the buyer does not take possession of and occupy the property as aforesaid. And I think it covers all the points. It says the seller is going to give notice, N12. It also says the tenant might not vacate. And it says in the event the tenant doesn't vacate, the buyer agrees to take over the property and assume the tenant. And then it says, adds an indemnification. Why the indemnification? Well, there's very strict penalties if you evict a tenant under an N12 because you need it for yourself or your immediate family, and then you don't move in yourself or your immediate family, you rent it out to somebody else at a higher rent. The tenant's got up to 24 months to go back to the board and challenge this, and the board will investigate, and if the tenant is right, the landlord could be fined up to at least $50,000, and the landlord can also be required to pay rent differential between what the tenant had to pay moving somewhere else and what he would have paid if he'd stayed put, or provide adequate accommodation for him. It's very, very expensive, very costly, and the problem is that the person who gave the notice isn't the person who's coveting to move in. The person who gave the notice is the owner of the property who's selling the property, and so he wants an indemnification from the buyer. So if you're not acting in good faith, I want you to protect me about any costs or expenses that might come up. What else can you do? You want to make sure that you anticipate the possibility the tenant might not move out. I would suggest you also use an L2 form. An L2 form is an order to evict, and it can be presented to the board anytime after the tenant's been given notice. You don't have to wait until the date that the tenant has to move out. And hopefully, it may not guarantee that they'll evict the tenant within the 60-day notice, but it'll get the wheels moving more quickly, and it's a way to cover yourself. So remember that L2 along with your N12. One last thing, you say, well, if the tenant doesn't move out, and as a result of that, the seller either gets sued by the buyer for breach or loses the deal, has to put it back in the market, and is carrying the property vacant now, or gets a lower price, can he sue the tenant? It's a good question. I'm not sure that he's going to be successful. I think the tenant's the culprit, and you may be able to argue the point that the tenant interrupted the contract through his actions, but unfortunately, on the N12, like all the forms that the Residential Tenancy Board uses, it has this statement. It says, you do not have to move out if you disagree with what the landlord has put in the notice. So you go to court, and the tenant's defense is going to be, Your Honor, right in this form that I was served, the eviction notice, it said I didn't have to move out if I disagreed. Well, I was challenging whether it was really a bona fide buyer who was going to move in, so I didn't move out. And I think that puts you in a precarious position legally to take action. So there's going to be problems, or there may be problems. Now, I would say to a buyer, the odds of a tenant moving out are very, very good. 9 out of 10 or 99 times out of 100, the tenant's going to move out. But in anticipation of the fact that they might not, and that's why you put in here that you agree to close the transaction, you agree to assume the tenant, you agree to take over the eviction process. And the buyer may not agree to that, but it's better to do that then than have the thing blow up on closing and have everybody with a problem. I hope that makes sense. I thank you for investing your time watching this video. I look forward to talking to you again next week.